Hello and welcome to BloombergQuint. You're watching the fine print. 6 months after the expert committee suggested changes to the competition law, the Ministry of Corporate Affairs has circulated its version for stakeholders' comments. The key proposals include the regulator may not inquire into anti-competitive practices if it has previously decided on similar or substantially similar conduct. Second, lowering the threshold for what qualifies as control. Acquisition of control makes a transaction notifiable to the CCI. So far, the competition regulator has used the decisive influence test to determine control. The ministry is now suggesting the material influence threshold. Introducing new thresholds for M&A approval. This is most likely to enable the regulator to review transactions in the digital space, giving relief to stock exchange transactions by doing away with prior CCI approval, tightening the noose around anti-competitive agreements where third parties facilitate a cartel, and expanding the scrutiny to cases where parties may not be in a horizontal or vertical relationship. To understand the implications of these proposals, I'm joined by Avaantika Kakkar of Cyril Amarchand and Nisha Uberoi of Tri-Legal. Avaantika, Nisha, welcome to the fine print. Avaantika, I'll start with you, and before I come to the specific changes between what we saw in August last year by way of the CLRC or the Competition Law Review Committee proposals and now what the MCA has circulated, were there any surprises for you?
You can always expect a few surprises, nothing that causes one to immediately fall off one's chair. But I think what you mentioned in the lead up, which is the section 26(2), which basically talks about the Commission's power to no longer actually restrains the Commission's power to examine something that it has substantially ruled on. It makes imminent sense, but if I remember correctly, the CLRC had also talked about clubbing. Yeah. Similar complaints, but of course the assumption is that they happen at the same time, yeah, or close. But as a departure, I think what the CLRC had recommended in this particular provision was that the Commission would not examine issues that are substantially similar to those it had finally ruled on. The way the amendment reads right now, one is not sure, and in fact it could be argued that even if on a prima facie stage the Commission has said I will not examine it or I will, then it can't look at that case again. Okay. Which is a little bit odd. And if you go back to the Civil Procedure Code, yeah, which lays down the principle of res judicata, what does it say? It says substantially similar, and the parties also to be the same. Yes. So frankly, I haven't had the time to study, and I don't know if anyone would have so far studied the implications of what would happen if you were to settle this between two parties that have fought at the Commission, and the Commission has ruled yes in favor, say there was an abuse of dominance and the informant's claim stands. What happens if another informant can't come before the Commission? Can he go to the National Company Law Appellate Tribunal to claim damages? Because very clearly our law is one that does not have standalone damages. You can't just claim damages without the backing of
it has to be pursuant to a CCI approval.
Precisely. So what if the Commission's missed out someone? Okay. Do his claims, are they forfeited for the simple reason of coming into this provision?
Okay, for the benefit of our viewers, I'll just elaborate on what this is about. Section 26 allows the regulator to take a preliminary or prima facie view before a Director General investigation is directed. The MCA is proposing that the CCI may choose to not look into a complaint of anti-competitive conduct if the same or substantially the same facts have been or issues have been decided by it in the past. Nisha, are you as uncomfortable with this proposal as Avaantika is, and to your mind, what could be the adverse implications of these recommendations if it's made part of the law?
So the adverse impact, if this is made part of the law, would essentially be that, at least from the point of view of Section 3, where the Supreme Court has already held that the CCI does not need to define the relevant market, facts and issues would pretty much be the same across cases. So to give you an example, if there was an investigation involving steel companies and if it was a cartel investigation, effectively the issues would either be price fixing, market allocation, restriction of supply, or bid rigging, right? So these issues will not change, and particularly if it's bid rigging, effectively the issue would be the same and the facts would be pretty much the same, that parties colluded in relation to a bid. What would change would be the time period. So I think the Commission here is going to have to specify whether they're looking at a shorter period in terms of clubbing, or if it's a long duration, whether they would then reserve the right, as they currently do, to reinvestigate and look at it as a fresh information.
Avaantika, would you not give the regulator benefit of doubt here? I think what they're trying to do is, let's say a bunch of complaints, let's say against the same parties have come in, and in a month of, let's say, in a span of a month or two, if the same kind of complaints, and at least the immediate ones that come to my mind are in the e-commerce space, it is for those sort of cases that the ministry is now proposing an enabling provision to say that the CCI can choose not to initiate. But would you?
No, it doesn't say it can choose. My reading is a little bit different. What it says is that the Commission will not investigate or not initiate an investigation on facts that it has previously ruled on, which are substantially the same as what it has previously ruled upon. So it's not just e-commerce. Let's go back a while. You remember the DLF cases, right?
Yeah.
There was quite a series of them. Then eventually the Commission started clubbing them because that's a reasonable thing to do. But they were different parties, right? DLF was of course constant, but there were different parties, right? So I think what it's saying here is that if you've ruled on something, and there are currently cases that we are arguing where there has been a ruling already, but somebody else has now initiated a complaint against the very same party for the very same, making the very same allegations, but there is also a twist. So I think the Commission in that case would examine the twist and not reinvestigate, were you dominant, did you abuse your dominance, because it's sort of already settled that. Which it would do in any case, but perhaps has not been doing. So I think this is intended to limit, rather not leave discretion to the Commission, but limit its discretion, which also brings me to something that has been happening in a lot of prima facie orders of the Commission. You'll see on the more complicated section 3.4, which is vertical restraints or abuse of dominance cases, the Commission says, I didn't have enough material on record to even take a prima facie view. But the counter to that is that the informant is unlikely to have that. That's why he's coming to the Commission. So are we saying, therefore, now that once that investigation has been forfeited even at a prima facie stage, supposing there's an informant who has perhaps some more context, is the Commission prohibited from looking at those cases?
So what should, given the intent here is, let's say, to limit and not have, like, say, similar kind of cases or multiple cases against the same entity, what tweak, let me take this to Nisha, what tweak would you suggest that the MCA makes to this provision?
So I think basically what needs to be clarified here is the fact that this provision will be used to ensure that there's no abuse of the process, where you don't have a single informant who repeatedly goes after a particular company but chooses to do so every 2 years, right, on essentially the same set of facts and issues, and therefore there are multiple investigations which are not clubbed because of the time duration, but they effectively are kind of overlapping to an extent. So to avoid that abuse of process and to avoid a wastage of public resources, such cases there should be complete closure, and that I think was the stated intent for the CLRC. It was not the intent that the Commission will not be able to look at the same sector again after a given period of time.
I also would tweak it with one little change the CLRC had proposed, which is the Commission should have passed a final order.
And not just
a closure
order of the
That's right, because what does it mean right now? The way the provision is worded, it takes away the word final order. So I can see a lot of litigation again before the courts saying, oh, they already passed the prima facie order and they can't do so again on the very same facts. Although there might be more context, there may be
more
information
or
more information.
Okay, so these two tweaks need to come in, that it shouldn't prohibit the regulator to look at genuine cases against maybe the same entity, if there are new sets of facts, etc., and it needs to be once the Commission has passed a final order.
Definitely.
Okay, all right. The second important one has to do with definition of control. The MCA has accepted the CLRC's recommendation that while determining control for the purpose of notifying a transaction to the CCI, the threshold should be material influence and not decisive influence. Nisha, to your mind, what's prompted this change in approach?
So the CCI throughout has effectively looked at decisive influence and did a very good job, in fact, of determining the parameters of control on the basis of decisive influence. In only 2 instances did they look at material influence. One of them is Agrium Potash and the other one was Ultratech JP. Okay. And only in these 2 cases did the Commission basically say that they will look at material influence and they look at special status and they look at special rights which are accorded. In all other cases, they went effectively with decisive influence, where they looked at certain rights, not investor protection rights, but certain rights which tantamount to control for the purposes of competition law. I think it's actually unfortunate from an ease of doing business and an industry standpoint to have the threshold of material influence being introduced, because material influence is effectively the lowest threshold of control. It's effectively going to result in unnecessary notifications being made to the Commission. It will block resources. It will be effectively burdensome on industry, because with material influence now, investors will be compelled to try and get information from a target which might not really be forthcoming when all the investor has is material influence. And material influence, frankly, is not even really a global standard. The European Commission pretty much uses decisive influence. It is only UK which uses material influence. So I don't think that this particular introduction, if it does go through, would be industry friendly at all.
Are you clear then on probably what deals today are not reaching the, I'm just trying to get the flavor of what kind of deals or acquisitions will now need to be notified as a result of this change in control definition, if it becomes a law?
So a lot of private equity transactions which would otherwise ordinarily have been exempt under the decisive influence standard will now be caught under the material influence standard.
Okay, we'll eventually see if it comes into the law, the repercussions of it. Avaantika, this next one would be your favorite. The Ministry of Corporate Affairs has now proposed that prior CCI approval should be done away with it for certain on-market purchases, like open offers and I'm guessing block deals as well. But this exemption comes with certain conditions. The acquirer cannot exercise any voting rights or dividend rights. The transaction will need to be notified to the CCI at a time when they specify in the regulations, and also convertible securities or shares will need to be maintained in a specified manner. Welcome change for sure, but what does it allow the industry to now do?
I think it addresses exactly the sort of deals you mentioned, which is block transactions. It also, I think, opens the doors for stock building, which in the past, as you know, has been penalized by the Commission.
That you do acquisitions in tranches,
as a build-up. It's not really an acquisition in tranches, but you could build up your stock, trade in it, and then on the side also decide that you'd like to make more of investment, maybe through negotiated purchase. So I think it just allows for more flexibility, very much in line with international best practice, very much in line with what happens in the EC, including the conditions upon which it is available, also in line with Brazil. And if I'm not mistaken, also Japan. So I think very business friendly, very good for private equity.
Yeah, because presently on-market purchases, as I understand, difficult because if you do notify to the CCI,
you lose
the price advantage.
The opportunistic price advantage that you are entitled to under securities laws.
Can you give me an insight into what these conditions could probably spell out if and when this becomes law and CCI decides to, further put out the rules on this?
Right. So basically, what it means is, and one could talk about how the modalities will work. But the obvious thing one thinks of is maybe an escrowing of the shares and the shareholding, and your agreement to specify that the rights will only be exercised, be they economic or voting rights, will only be exercised once the CCI has cleared the transaction.
Okay.
So what the Commission is saying is go ahead and do that trade, or the series of trades. When you're ready to report it, let me know.
Okay.
And I will give you the approval in the ordinary course. You might even meet the green channel conditions, for instance, which, as you know, is the simplified filing. So you know, the normal process applies to you, except that you're able to conclude your trade.
So let me, Nisha, talk to you about the next key proposal, which is to include hub and spoke kind of arrangements within the ambit of anti-competitive agreements. Again, could you weigh in on what lacuna presently exists in the law as it stands that the MCA is now trying to address through this proposal?
So currently, the provision which deals with cartels doesn't expressly stipulate a hub and spoke cartel. So what's being done through this proposal is that effectively it's being codified very clearly and spelt out in the law that just like hardcore cartels, similarly a hub and spoke cartel will be treated on the same basis, and there will be a rebuttable presumption which will be available to parties. And what's also being made clear is that because it's a hub and spoke, you don't need to be at the same level. As long as you're actively participating, you will very much be caught under the ambit of cartels.
Do you want to give me an example on how?
Side, because this is being introduced as.
Nisha, can you also, before you make your second point, could you also sort of explain to our viewers how does typically a hub and spoke kind of cartel works?
So basically in a hub and spoke cartel, you'll have people at different levels of the production or distribution chain. So to give you a very simple example, Avaantika and I are lawyers, Payaswini here is the journalist, right? So Avaantika and I operate in the same relevant market, which is the market for provision of legal services. Payaswini operates in a separate market. We could therefore be vertically linked. And instead of Avaantika and me exchanging information directly, competitively sensitive information, I tell Payaswini with the intent that she will then transfer this information to Avaantika, and Avaantika does the same, where she gives her information to Payaswini to effectively share with me. So we are now operating on a hub and spoke cartel basis through this arrangement where all of us are not necessarily at the same level because Payaswini is not in the market for legal services, but we're using Payaswini to exchange information indirectly. This will now be caught the same way a normal cartel would be caught, and therefore this, from a pure play competition perspective, again brings in a new angle where as part of this hub and spoke cartel we would have the right to also file for leniency.
All right, I did not sign up for this
So
example.
the concept of introduction of the hub and spoke cartel itself.
Yes. Yes.
I'm not sure that's the best example before she gives any ideas to the CCI.
Yeah, I know. I don't know how I got caught up in the middle. I'm just asking questions here. Avaantika, also there are some anti-competitive agreements, let's say between competitors or parties who are vertically linked that presently are barred under competition law, but the MCA and both the CLRC are of the opinion there are certain kinds of agreements that are strictly not caught in this equation. There is a proposal to get those kinds of agreements also within the purview of Section 3. Could you sort of also illustrate, not using me as an example in any fashion, what could those agreements be and why the need to enhance scrutiny on them?
Sure. So I think a lot of the changes that you see are enablers, and in anticipation of the great change that might come about or is already happening on digital markets, on platforms. So I think the idea was that during the CLRC discussions as well was to sort of provide for a situation fairly vaguely, if necessary, that could be fit in where it didn't clearly fall in the strict parameters of the Act. It was neither vertical nor horizontal, but what was it? Was it a sort of hybrid arrangement? And if so, which provision applies to it? Exactly the sort of thing you take to writ court.
Right.
So the idea was to really provide for that situation and that eventuality.
Any examples that you can think of, maybe in the past, that have come up before the Commission?
So the CLRC was inspired by the famous Hiranandani case, which, as you know, involved a patient, a consumer, and really the argument, and it was accepted in appeals, was that she was not part of the value chain. So the arrangement with her was neither vertical nor horizontal, right? So I think that's the sort of arrangement that that inspired this change, because everyone realized that there were effects on the market. Just because you couldn't classify that arrangement as either a vertical or a horizontal arrangement was not a good reason for someone like the competition regulator to not examine,
scrutinize that transaction.
That transaction.
Okay. I know there's a lot of hue and cry around this, but the MCA is also now batting for, let's say, a deal value threshold for transactions in the digital market. Nisha, the CCI gave the CLRC gave the example of Facebook, WhatsApp, your Flipkart, Myntra, your Snapdeal and Freecharge kind of transactions, to say that just because these transactions didn't meet the turnover or asset thresholds, the CCI's approval wasn't required, and that needs to change. Do you, either of you, disagree with this proposal?
I think it's a very fair proposal, because this is something that other jurisdictions also do. Germany and Austria both have these thresholds. The US also has a transaction size threshold. In addition to that, the US has the ability to look at all non-notifiable mergers. So the change which is proposed is actually quite sensible, in that it doesn't look at all non-notifiable mergers, but there will be the ability to look at special deal value thresholds. And again, what the CLRC recommended is that these be quantifiable, and more importantly, that they have a local nexus to India.
Okay.
Right. So I think following on the heels of Germany and Austria, but if I am to understand correctly, I'm not sure if either Germany or Austria have seen the kind of transactions they imagined they would have the opportunity to scrutinize.
Okay.
So I think it may be worth talking about that. I think the regulations are going to have to clarify things like staggered consideration. Now, in the quality of transactions that you're looking at out here, you'd probably keep the promoter in for some time, the founder promoter, and then that exit would be phased out. And things like that. So staggered consideration, at what point in time do you count that? How do you count it? I think similarly for cross-border transactions, do you look at the global number? Do you look at the number attributable to India? Sometimes there is no number attributable to India in global deals. So I think it's quite a task. I wonder if it's worth the effort. But yes, there is a general agreement in international authorities, competition authorities worldwide, that they'd like to examine transactions in the digital space. But I'm not sure this is the best way to achieve it.
Okay, all right. Even the CLRC mentioned a bunch of things that the CCI will have to deliberate over if this...
Just to clarify here.
Sure.
Faiswani, just to clarify here, that while all of us keep picking up on digital economy as an example, because that's what the CLRC has stated, currently the proposal is such that these deal value thresholds can be introduced for any transaction. It is not necessarily restricted to digital economy transactions.
Yeah, but I think the thought is emanating from there, if I'm not mistaken.
It's interesting to watch how this will finally evolve.
Yeah, sure. Yeah, point taken, Nisha. Avantika, the other interesting proposal that I found was the protection to intellectual property rights holders under Section 4, where essentially they are saying that if you're using or exploiting your IPR in the relevant market, and then you're accused of abuse of dominance, the fact that you are exploiting an IPR will be available as a defense to you. How useful to your mind is this proposal, and also some of the older cases where parties may have taken this defense and it didn't sort of really fly?
Yeah, I would say those are the cases that inspired the change. I think it was only fair that if the defense was available for vertical restraints, it should also be available for the abuse of dominance. Having said which, let me be very clear about it. It does open up a line of defense. How effective that will be is something that one has to really study, because
it can't be a blanket protective sort of
it usually
defense.
is not. Intellectual property rights and the assertion of any sort of exclusivity is at direct contradiction with competition law.
Yeah.
There never will be peace between the two.
Yeah.
So I think it does open up a line of defense. At least when you start making the defense, you won't hear from the Commission that it's not available to you. You will be free to make the argument. Whether or not it's accepted in that circumstances remains to be seen.
Just maybe useful mentioning here, the auto parts case,
yes.
I think this defense was brought forth, and
yes. One of the defenses to not making parts and drawings and specifications available to everyone on the open market was that it was the intellectual property of the car manufacturers. But the Commission, if you read the order, paid absolutely no attention to that defense.
Okay, at least this is available now. In
Yes.
what shape, form or threshold, we'll probably
Remains to
see.
be seen.
My final question, Nisha, is something that I mean you both might be upset with, and that's the proposal of reducing the deal approval timeline from presently 210 days to 150 days. I would have thought a quicker CCI approval will make all of you happy.
So a quicker approval from an M&A perspective is always very welcome. The concern here is not around the quicker approval in as much as reduced timelines for industry to be able to respond and to convince the regulator in the first instance that a deal should not be taken to a phase 2 investigation. What the current proposal on the table has is that effectively the timeline will be reduced from 30 days to 15 days for industry to respond as to why this transaction should not be taken for a full-blown phase 2 investigation. At this stage, parties need more, not less time to be able to get all their defenses in place to be able to convince the regulator. So I think that's the first leg which really needs to be addressed. And at that stage, it's better that we go back to what's on the statute books, which is the 30-day period to respond, as opposed to the current reduced timeline of 15 days, which is proposed. What's very welcome in terms of what is on the table is the fact that now parties will have the ability to come forward with their set of proposed modifications as opposed to waiting for the regulator to tell you what to do, right? So this gives you the ability to actually determine at this stage what it is that you're willing to offer and negotiate with the regulator around it. The problem around this arises again in terms of timelines, where if the regulator disagrees with what parties propose, then the regulator needs to communicate this to parties within 7 days, which gives the regulator only 7 days to look at what these remedies are and whether they would meet the purpose of that appreciable adverse effect on competition. And here is where the proposal on the table doesn't address what the CLRC recommended. One of the CLRC recommendations was there should be market testing of remedies, and if the regulator merely has 7 days to consider whether the remedies being proposed by the parties are adequate, clearly market testing is not going to be possible. If the regulator disagrees with the remedies which parties are proposing in a transaction, then parties have 12 calendar days to come up with a revised set of remedies, and 12 calendar days in a global transaction or even in a massive domestic transaction is not going to be sufficient time, because you need to go back to drawing board to determine what new remedies you're willing to offer the regulator, since the first set of remedies didn't work out. And more importantly, you'll need buy-in of various stakeholders. If it's a listed company, you might need to go up to the board. So therefore, this 12 calendar days is not really a practical timeline.
Okay.
So
Avaantika, Nisha has made a very compelling case.
From 210 to 150 doesn't work.
Yeah, Nisha has made a very compelling case against these reduced timelines, but who's complaining against the time that CCI is taking? Because I thought they were doing a good job.
No, absolutely. I think the standard that the Commission has set timeline-wise is exemplary, and I can say from my experience that this is well acknowledged internationally. So I don't know if someone's trying to fix a problem that doesn't exist.
Yeah.
That's one. Second, I think while Nisha's given us the details, I think the short point really is that this is going to put time pressure on the parties themselves. It's going to put a lot of administrative time pressure on the case officers. They will have to write you that letter, which they currently don't, by the way, to stop the clock. Right now, clarifications happen over the phone, they happen over meetings, and life goes on because it's a sort of comfortable timeline for all parties involved. Now, the moment you compress that, the parties are going to hurry. They're going to have to hurry, and the case team is going to have to hurry, and they just have to. Someone's got to stop the clock. I can see parties asking the case officer to write them an RFI so that they have time to think about it. So I think that problem doesn't exist. It doesn't need to be fixed.
All right. On that note, Avaantika, Nisha, thank you for joining us with your first quick thoughts on the major changes that MCA is proposing in the competition law. And as and when these become a reality, we'll get back to you on the effects of those. Thank you so much for joining here on BloombergQuint, and thank you so much for watching.